This is another episode in the Austin Constitution Meetup of October 15th, 2013. In this video, I'm going to be discussing mortgage fraud. Now, there's been a great deal of discussion of mortgage fraud in the last few years, but I want to examine some aspects of it, basically how to prevent it. Most of the focus has been on how to avoid foreclosure, but I've had the occasion recently to examine a presumably typical note and deed of trust for the purchase of a house, and what I found was somewhat alarming. Now, we used to be in the real estate field. I was a real estate agent back in the 60s and 70s. I wrote a lot of the paperwork for many real estate transactions. I didn't leave it to the lawyers. Many of the deals in which I was involved were complicated enough that the standard forms used by lawyers were not always adequate, although we used them to the extent that we could. In those days, the standard form for a deed of trust in Texas was a state bar form. It's a long, two-page document, very fine print, which, by the way, was one long sentence grammatically, which I found rather interesting. But it did provide protections of the rights of both parties to the deal. It wasn't just all in favor of the lender. It also protected the borrower, the purchaser. Now, when I was a purchaser, and I frequently was, I invested in a lot of real estate, I would typically also add provisions to the deed of trust to provide additional protections. And I almost always got the seller to agree to them. Now, what was in the original deed of trust form? Well, one of the things that was in it was simply the provision that once the note was paid, the deed of trust ceased to exist. It didn't require a release. It was released by simply paying off the note. Now, most title companies wanted a release anyway, as evidence that it had in fact been paid off. But all that was really required to terminate a deed of trust was a note with the word paid marked across it and signed by the owner and holder of the note. That was all it took. Now, there were other provisions that I typically added to the deed of trust, provided, for example, that the borrower had to be notified of any change of address or ownership of the note, so he would always know where to send payments. And I further provided that if there was ever a failure to notify the borrower and payments were made anyway, that all such payments that were issued to the last known proper recipient and address for the note holder had to be considered valid, even if they didn't make it to the owner and holder of the note. So you could not have a situation, as has occurred to some friends of mine a few years ago, where they were buying a home, they made all the payments, the servicing agent who was actually collecting the payments, went bankrupt. The owner and holder of the note foreclosed on the house, evicted them from their home, and when they protested, they had made the payments, says, well, you're just an unsecured creditor of the servicing agent. Now, I had not actually anticipated that sort of thing might happen, at least not, I hadn't thought through it in any great detail. But when I was writing such deeds of trust, but in fact, the language that I would typically add to a deed of trust would have prevented that situation. I also required that in some cases that the borrower had to give consent to any change of ownership of the note and deed of trust. So, and if he made all payments, or if there was only a dispute concerning the amount of the payoff, the owner and holder of the note could not accelerate the note and add 10% attorney's fees just over a dispute over the balance. It could only be done if there was actual refusal to pay. So I covered a lot of contingencies in a way that would provide additional protections to the purchaser of the property and the maker of, the grantor of the deed of trust. This provided a level of protection in that day and time. In fact, in that day and time, typically all these transactions went through a title company, which had a lawyer, and the lawyer would not allow a deal to be made that was too unbalanced in favor of either the buyer or the seller. And I, as a real estate agent, would never have allowed any of my customers, either my sellers, who I, of course, was working for on commission, or my client, my buyers, to enter into a deal that was not fair to all parties. I had a fiduciary responsibility, in my view, to make sure that all parties were protected, that everybody came out ahead. My mother and I had an ethic on the subject that, we agreed that a deal was only a good deal if it benefited all parties. No zero-sum games for us. So that was the way things proceeded in the 70s and 80s. Somewhere along the way, that broke down. And lenders started using their own deeds of trust, of which the one I examined recently is apparently a typical example. It has no protections at all for the purchaser of the property, for the borrower. None. In fact, under the actual written terms of that note and deed of trust, even if the borrower paid off the note completely and on time, there's nothing in it that really requires the owner and holder of the note to grant clear title to the property. In principle, he could have paid it all off over a 30-year period and still lose it. And he would have no recourse. They could have simply, at the end of the 30 years, note paid, just evict him, as though he were a tenant at will instead of the purchaser of the property. In other words, these current notes and deed of trust do not confer any rights to an equity on the part of the buyer. When you sign one of these notes and deeds of trust today, you're signing away all rights. All you're doing is being allowed to be a renter of that property. If they ever give you a clear title, It's just because they're feeling good that day. It's not legally required of them. And you probably cannot successfully sue them to get a release of lien. Now, that means that essentially you're better off leasing the property than you would be purchasing it. Because at least if you leased it, the landlord would have a duty to maintain it, at least to do major maintenance. He might provide that you take care of minor maintenance, but if a roof leaked or the sewer overflowed or the plumbing broke or anything like that, he would have to come and pay it. And on these so-called purchase agreements, you're stuck for the entire bill. So, and you're also stuck for the taxes if the lender doesn't pay the taxes from under the typically the escrow agreement. So, no one should purchase or refinance any piece of real estate under the terms now being offered and demanded by mortgage lenders. Anyone who does it is a fool. And you have no one to blame but yourself. You have no protections, no recourse. It's useless to try to go to court and sue because the note and deed of trust as written provide you with no protections whatsoever. And if you had a lawyer advising you on the transaction, and you should have had, he committed malpractice and should be disbarred. And in my view, all the lenders that loan money for the purchase of houses under such terms should have all of their debts declared null and void. They should be put out of business. The loan officers should go to jail. They should be sentenced, I would say, fraud, typically 5 years in prison, consecutive 5 years prison terms for every mortgage that they enter into on that basis. And so I hope that this video becomes viral because you need to spread the word to everyone who might contemplate purchasing a house using a mortgage under these terms, to refuse to enter into a mortgage, a deed of trust that does not provide that it, first of all, that there must be a release of lien when the note is paid. Secondly, that requires the borrower to be notified of any change of ownership of the note and any change of the trustee on the deed of trust. That requires that any payments made must be credited, even if they don't make it to the owner and holder of the note. And that if there's any dispute over whether the payments were made or what the balance might be, the lender may not accelerate the note or add attorney's fees unless and until the amounts are settled. So these are the critical elements that need to be included in any note and deed of trust, and you need to insist on them being there. And if they're not in the deed of trust, don't sign it. And if you get a lawyer to advise you, make sure that he recognizes that you will sue him for malpractice if he advises you that you are protected when in fact you are not.
Would this shed any light or perhaps draw a contrast between what appears to be overwhelming now is just fraud and stupidity. And there were periods where all of this was done quite ethically. How might this be compared to the idea of a warranty deed?
Well, originally almost all deeds were warranty deeds, which meant that the maker of the deed, the grantor of the deed, as opposed to the grantor of the deed of trust, which goes in the opposite direction, warrants that good title to the property. In other words, he's saying that he is the owner of the property and therefore has the authority to convey it. And that if the title is later shown to be invalid, that he guarantees to correct it, which means either refunding the money paid for it or clearing up any defects in the title. And what title companies are supposed to do is to ensure clear title. They're supposed to do a title search on the transaction to make sure that the seller is in fact the owner, and that he therefore, in conveying title in that deed, is in fact authorized to do so, and there are no clouds on it. Now, there is several aspects to this. First of all, it's a good idea for buyers to do their own title searches, because title companies can miss things. And I used to do my own title searches, and I often found things that the title companies overlooked. They often merely did a title search of what they could find in the courthouse and neglected to look for other things that could eventually be clouds on the title, such as, for example, work that might have been done that might have incurred a mechanic's lien, which doesn't necessarily get filed with the courthouse. So there are a lot of things that can go wrong when you're doing this kind of thing, and it's a case of buyer beware. Now, with the proper handling of this transaction, where there are protections for all parties involved, one can reasonably ensure that a lot of adverse consequences will never occur. One of the reasons why the ethics worked in those days was because people were careful to make sure that if anything went wrong, there was recourse. Now, Texas had then as now non-judicial foreclosures. But non-judicial foreclosures worked because everybody involved knew they could get into trouble if they tried to game the system. And where it began to go wrong was with securitization. It used to be that your lender was your local bank or savings and loan. The chances are you knew the loan officers personally and had known them for years. When I used to borrow money for more things like purchases of real estate, I knew my bankers. I knew my savings and loan officers. I mean, I was a member of the savings and loan. It was a membership organization, the way credit unions are today, still are, some of them. My banker was somebody my mother had grown up with, gone to school with. And the bank, or savings and loan, serviced their own loans, and they kept them. They didn't sell them to anybody. They didn't bundle them into a security and ship them off to parts unknown. So when it came time to pay off your note, and you did, you got a release right then and there from the same guy who made you the loan. And he had a reputation to maintain in the community. If he abused people, people wouldn't deposit their money in his bank, and he'd go out of business. So everybody had a stake in maintaining good reputations. And the whole thing was based upon personal knowledge of one another and personal reputation. And once securitization set in the 80s, that's when it all started going to hell. Because after that, all these transactions began to become anonymous. Everything was by the numbers. There was no longer a personal involvement on the part of your local lender. And in fact, one of the things that happened at the same time was that a change in the tax law, tax code, made investment in real estate less profitable. You could no longer write off some things you could before, and suddenly a whole lot of mortgages being held by savings and loans, the underlying property became worth less than the balance on the mortgages.
Because of the change in tax laws.
Because of the change in the tax law. And the result of that was that suddenly almost all the savings and loans were insolvent, technically. And so the FSLIC, the equivalent of the FDIC for savings and loan associations, scooped in and shut them all down. Now, in fact, as long as people kept paying, they were not insolvent, but they had an excuse to declare them insolvent and shut them down. They got bought up for pennies on the dollars, mostly by the big banks, who then had the same thing happen to them, and that's how we got the few large bank chains. The big banks gobbled up the little local banks. Most of the banker friends of mine that I grew up with lost their banks. They got bought out by big chains. So that was the change in the situation. And of course, after that, personal knowledge of by the banker of the borrower was no longer important. There was a time in those days, if I needed a loan, I could, for any reason, all I had to do is pick up the phone, call my banker's secretary, whose name was Cassandra, by the way, said, Cassie, I need $20,000. Says, okay, John, I'll put it in your account and you can sign the note the next time you're in the bank. That worked in those days. Next time I came in the bank, I signed the note, closed the deal, but I already had the money, was already doing business with it. And of course, the big crunch came when, following the oil shock of 1973 and the collapse of credit, that I would go to the bank and suddenly they were calling me and saying, can you please pay off your loans, we need the money. That's when the things began to go south.
So all of that is just regulation, big changes in the world,
Yeah.
making it much more difficult to make a profit in the banking business. And did that actually set the stage for the securitization?
Well, in a way it did, yeah, because a lot of lenders found they had to securitize in order to avoid going out of business.
And the securitization is, they're basically out making loans that they know they can't afford to keep on the books, so they sell them to somebody else.
Right, but they bundle them into bonds. They take a bunch of mortgages, put them together, and create a bond for it,
Okay.
backed by those mortgages. Then they start peddling the bond. Well, the bond can begin to become peddled, sold and resold for a lot more money than those mortgages are worth. And there's no real examination of the underlying mortgages to find out if they're worth as much as the bond is being sold for. So in fact, they could be bad loans. They could even be loans that are all about, within a month of being paid off. Of course, once they're paid off, no more revenue. So what is a bond backed by mortgages worth that are all about to come due and be paid off? Well, the answer is nothing. But that's not disclosed. So it became a big, kind of a Ponzi scheme.
Yeah. Shell game.
Yeah,
Ponzi,
Yeah.
shell.
And it was not to be too surprising when it came crashing down in 2008. But of course, the problems that came to light in 2008 have not been solved.
Well, and they're all,
All we did
correct
was,
me if I'm wrong, they're all strictly political.
well, in a sense, they're also, of course, speculative, which is a kind of problem in itself. What the government did is pump money into the financial sector. Essentially, they inflated the bond market, which then fed into the stock market. So it kept stocks and bonds from collapsing. Now that doesn't necessarily benefit the general economy. The speculators are not using the money that they make speculating in stocks and bonds on building new businesses. They can make more money speculating within the financial sector than they can by investing it in industry and businesses and
Paying it back
things.
into society.
Yeah. So when you wonder why business is not growing or why they're not hiring and producing more, well, if you talk to a lot of these big businesses, and it's mostly big ones now, they'll can quite candidly tell you, well, we make more money investing in the financial sector than we do by making and selling products or by hiring people. The business sector is sitting on more than enough money to hire every unemployed person in the United States. But they don't do it because the rate of return on doing that is not as high as it is on investing it in stocks and bonds. So if we really want to cure unemployment, we need to let the financial sector collapse. So the money has nowhere else to go but into the productive sector of the economy. But of course, there's no graceful way to do that, because the way they're all tied together, if you let the financial sector simply collapse completely, it would take the productive sector with it. Therefore, my metaphor of the mouse with a tick on its back that's sucking blood out of it and growing by sucking the blood, swelling until the poor mouse can no longer move. Well, the tick is the financial sector. The mouse is the productive sector. What the government has been doing with quantitative easing is pumping more blood into the tick so that it doesn't suck so much out of the mouse that it kills it. But eventually, the tick is going to burst. But instead of burst and scattering blood all over the cage, it bursts through its mouth and feeds all that blood into the mouse, killing it. So and when the blood goes into the mouse, that's called hyperinflation. So we have a lot of pathologies here, and if buyers and borrowers of real estate had insisted on the kinds of deeds of trust that we were using in the 70s, 60s, and 70s, the whole thing could have been avoided.
Now, something more related back to the detail at the personal level is something that we've recently become aware of. A lot of these, and the one that's started our interesting safari is a refinancing. The paperwork produced in the refinancing, for what we're able to see, there was not even a deed of trust. Depending on what more may be found, how much of that do you think is going on? In other words, somebody buys, they don't check, and then people start to investigate, and there's not even a deed of trust to find.
Yep. Well, of course, in this, in the case you're referring to,
is that perhaps because there's not a title company?
Well, in your case you're referring to, apparently if there was a deed of trust, the refinancer, the homeowner, didn't get a copy because you haven't been able to find it in their records. Now, it might exist in the courthouse. We can go there and find out. If it doesn't exist, then the authority that they have under any refinancing agreement seems to be void in itself, because terms are certainly different than they were in the original note. And the original deed of trust is not going to work for a new note. You would need a new deed of trust. Now, one of the things too that used to be the standard, in law there's an old rule called the best evidence rule. If you sign a note and somebody tries to sue you for payment of the note, they have to produce the original signed note in court. The best evidence of the obligation is the original signed note. And the rule has always been that if they are unable to produce the original signed note, that there is no obligation. And it has to be declared, the court has to decide in favor of the borrower, essentially canceling the obligation. And what's been going on through all this time is that lenders have been simply going to courts and saying, filing an affidavit that they are the owner and holder of the note and that it's in default, but without producing the note. And in some cases we found they've either lost the note or have actually shredded it. But the way it works, each original signed note is a separate obligation. If somebody ever tried to sell you a house and they gave you 2 or 3 copies of the note and said sign each one of them, don't do it, because each note is a separate obligation. So it can only be one note for one mortgage. Can't be any duplicates. You can have unsigned copies that are, passed around for people's records, but no original signatures. And in fact, I once had somebody try to sue me on a note, and they had apparently lost it. I had reason to believe they had lost it. So when they tried to produce it in court, they produced a forged copy. They tried to sign my name to it. And of course, I could show the judge, this is not my signature. I did once sign a note like that, but this is not it. And they lost. So
it should always be that simple.
Yes. So, of course, in another case, we're not involved, we're talking about forgery, there was a transfer of title to a piece of property that was forged. There was, in fact, a transfer, but it had never been delivered, and somebody found it, whited out the recipient, and signed their own name on top of it, and then tried to resell the property. Of course, in the photocopy of the deed, it didn't show up in the courthouse records. They just made a photocopy of it. The whiteout was good enough to cover that up, but I happened to get a hold of the original. So I presented it in court, and of course that shot down that case. So I've had some interesting adventures in real estate, and I've had to contend with lawyers for the opposition who would go into the courthouse and steal documents from the court dockets, from the court files. So I had to make very, very sure that I always had my own copies of everything, because I was up against lawyers who would go in and steal stuff or substitute forged copies of things in place of the originals. The court records were wide open then. In those days, it was assumed that any lawyer was an honest person and that he would never do anything like that. Well, they may have been at one time, but that began to break down about that time, and I saw plenty of instances of it. So
This all speaks directly to the fact that if you're going to get involved in something like that, pay attention and be sure of all the details.
Yeah, well, a
And
lot of
keep
people are
records.
advising people who are facing foreclosure, if they suspect that the lender has not been handling the paperwork properly, to file a suit for quiet title. That might work if all payments have been made on time. But if you pay them into an escrow where they're without the consent of the lender, you are technically in default. And the sad thing is that won't help you, probably won't help you, if your deed of trust is like the one I examined. Because a suit to quiet title would not work with that paperwork. You are doomed with that paperwork. So I'm advising people, tell everybody far and wide, do not purchase, do not refinance with the kinds of deeds of trust that they're going to try to foist on you. Insist on the terms that I laid out in the beginning of this video.
To protect both sides.
That protects both sides. Not unequal, not in your favor only, but not on the seller-lender's favor either. It needs to be two-sided and protect all parties. It doesn't hurt to throw it, if you insist on certain terms like these, such as that you have to give consent to any transfer of ownership of the note. Now, they might object to that, but what you can do is insist on consent to any transfer of ownership of the note out of state. Now, if they want to trade it in state, that's one thing. If they're going to trade it out of state, that creates a problem in trying to enforce your rights. So it's perfectly reasonable to get your consent for such a transfer. But of course, that would pretty well shoot down the use of that mortgage in a securitization system. So you can see that if people have been wiser back in the 60s, 70s, and 80s, they had insisted on proper deeds of trust, we could have avoided this entire financial debacle. And it's not too late to start insisting now on proper deeds of trust going forward. Right now, most people, if they are in that situation, might as well just walk away. All they are is tenants at will, with the duty to pay for maintenance. They'd be better off leasing the property. So you don't have any equity that you can lawfully claim. Just forget it. You've lost. You lost when you signed the document. And going forward, insist on a note and deed of trust that's properly done, and if not, don't make the deal. Rent instead or something. If enough people do that, if they can't sell to anybody that doesn't insist on a proper note and deed of trust, it will solve the problem in going forward.
It'll force them.
But it's up to you.
It'll force them to be
Yeah.
accountable.
Yeah, no one else can protect your rights except you. You have to learn enough to protect your own rights. Don't just sign anything that's put in front of you. Not only read every word, but understand every word. And if you don't understand it, ask a lawyer. I mean, I hate to tell people to hire a lawyer for doing something that they should be able to do by themselves. But I'll tell you, I was a lot better off because I did that. And of course, that's largely how I began to learn law. I learned law through starting with real estate law. And everything else has been built on that since. You have to learn. Anyone who doesn't learn a certain amount of law in this society is prey. He's prey for lawyers and bankers and people who know the law better than he does.
And cops who don't even know the law.
Yes. So, like I say, spread the word. Don't let your friends and neighbors sign mortgages like the ones being used by lenders today. Insist on terms that protect your rights.